Well, good evening, everybody, from very bright and sunny Scottish borders today. It's been very pleasant. I've been outside even doing a little bit of gardening, or at least a little bit of work on the garden. Just before we get onto the articles, just to let you know that, as some of you saw on Tuesday just gone, I had a lengthy chat with Shetland musician Peter Wood. We're going to have another chat, not this coming Tuesday, but the following Tuesday, and hopefully have a guest with us that was mentioned a few times in the first video. But I'm very delighted to say that this coming Tuesday, 8:30 my time, so that's 2:30 Central Time, I'm going to be chatting with one of the legends of the Scottish Ceilidh Scottish dance band, Scottish accordion scene, John Carmichael, who was one of the stars on a very popular TV program called Thingamajig. Anyway, that's coming up on Tuesday. Hello, Julian. Hello, Paul. Great name there, Paul. So a couple of articles which I saw today. The first one via a tweet from Steve Drizin. So we'll look at that one first of all. We'll have a look at the tweet and then the article. So here was the tweet from Steve Drizin. This was in my inbox this morning. Stephen A. Drizin, Brooklyn DA details shocking police prosecutor misconduct behind 25 wrongful convictions and 426 years of prison time. So let's have a look at his art. I would just say, though, if you could go along and give Steve a like. I know that, well, it seemed as if Steve took a break for a little while. I know that Laura Nyrider is doing the same. They need a break every now and again. But Steve is back tweeting, so please do go and give him a like. I know he'll appreciate that. So let's look at the article. It's the Brooklyn Police. Here we go. But I might just go a little bit bigger. That's better. So it's easier to read. Brooklyn DA details shocking police prosecutor misconduct behind 25 wrongful convictions and 426 years of prison time. This is yesterday, July 10th, by Michael Fitzgerald, the New York editor, The Chronicle of Social Change. December 19th, 2018, Brooklyn District Attorney Eric Gonzalez. Credit, Brooklyn District Attorney. Okay, describing injustice as an almost unbearable, describing injustice of an almost unbearable magnitude, Brooklyn's District Attorney Eric Gonzalez this week released a report concluding that police and prosecutorial misconduct contributed to the wrongful convictions of 25 New Yorkers by his own office. The deeply unsettling result was 426 wasted years in prison for serious crimes that each of the 26 people did not commit, including homicide, assault, and burglary. 5 of the 25 wrongfully convicted were 18 or younger at the time of their convictions, and they served from 7 to 29 years before being exonerated. Only one of the 25 defendants is Caucasian. Each case described in these pages is itself a complete tragedy for the person who was wrongfully convicted and incarcerated, for his or her community, for the victims and survivors of these cases, and indeed for all of us, Gonzalez wrote in an introductory note to the 100-page report released Thursday. I am mindful that we are publishing this report at a time when the killing of George Floyd in Minneapolis and the racial violence it has called up have filled so many Americans, including me, with anger and despair. Much of that anger and despair is directed at the criminal legal system and those who work in it. Gonzalez's report is a uniquely specific reveal from a top law enforcement official and a bold public detailing of his predecessor's mistakes. The report states that police misconduct played a role in 18 of the 25 wrongful convictions. In 21 cases, the wrongful convictions involved prosecutorial misconduct. One man, identified in the report as Tony Stevens, names which all changed to protect the exonerate's privacy, did not live to be exonerated. He died in prison after 15 years for carjacking, related murder, kidnapping, robbery, and weapons charges filed against him when he was 16 years old. The case analysis led by Gonzalez's conviction review unit suggested that police had coerced the young teen into confessing, along with 7 other exonerees, 5 of whom were 18 and younger. The conviction review unit within the prosecutor's office was launched in 2014 to determine whether prosecutors used their broad discretionary powers to secure a reliable, fair, and just conviction, the report states. While many of the 25 vacated convictions in the report have been widely covered in the media in recent years, the new report details why the unit staff of 8 full-time prosecutors recommended that the convictions be overturned. This is the first time that any elected prosecutor has invited outside lawyers, researchers to review the office's own files from conviction review into investigations and make those reasons public, said Nina Morrison, Senior Litigation Counsel for the Innocence Project, which assisted Gonzalez's office and the law firm Wilmer Cutler Pickering Hale and Dorr, LLP. Stevens' case began in 1985 when a victim was carjacked and found dead the next day, shot to death with a .22 caliber revolver. Police pursued a vague tip from 2 men who should have been suspects, according to Gonzalez's team, before settling on Stevens and another 16-year-old identified in the report as Scott Moore. Evidence indicated neither boy had a license, had ever driven a car before, nor had access to a car. Neither of the pair's DNAs or fingerprints were found on the stolen vehicle, and the appearance in no way matched descriptions from witnesses. To believe their confessions, one would have to accept that the 2 boys drove continuously for hours in traffic during the day from Queens to Brooklyn while holding their victim in the back seat of the car at gunpoint, and then later gassed up the vehicle at a self-serve filling station and parallel parked on a street, the Brooklyn prosecutors wrote. Moore's and Stevens' videotaped confessions were shockingly brief and perfunctory for such an elaborate crime, the report says. The pair have claimed that they were coerced by police. Moore said detectives slapped him in the face and threatened to hit him with a chair, according to the review by the very office that prosecuted the pair. Stevens and Moore were alleging that their confessions were false by the time their trial started, like all 5 other defendants in the report who falsely confessed. In all but one of those cases, the confessions were the only direct evidence presented in the trial to connect the defendant to the crime. Yet, in each instance, they were convicted by juries, in significant part on the basis of the confessions. False confessions have been the subject of intense advocacy in recent decades, ever since DNA evidence first played a role in overturning 2 convictions in 1989. The Innocence Project has counted 367 exonerees since. 17% involving defendants younger than age 21. Roughly 100 of the exonerations involved a false confession, nearly half of which came from innocents under the age of 21. Gonzalez's report quotes John Jay College of Criminal Justice Professor of Psychology, well, where have we met this fella before? Saul Kassan. Saul Kassan was one of the people that wrote an amicus brief for Brendan Dassey that the Supreme Court did not look at, and is highly regarded as one of the top wrongful false confession experts, along with Steve Drizin, Richard Leo, Brian Cutler, Richard Offshee, and a few others. Anyway, yes, Saul Kassan, who has found strong evidence that juveniles are at risk of involuntary and false confessions in the interrogation room. The issue became the subject of national attention after the 2002 exoneration of 5 boys who were convicted for the brutal attack of a jogger in New York Central Park. As a result, many states began requiring videotaped interrogations, with Virginia becoming the 27th state to do so last year. All federal law enforcement agencies record in-custody interrogations of crime suspects. New York enacted such a law in 2018. When They See Us, the Ava DuVernay series on Netflix about the Central Park case, revived interest in the issue nationally last year and is helping advocates push for further reforms to interrogation, said Rebecca Brown, policy director of the New York-based Innocence Project. Yeah, I would probably say that you've got another Netflix documentary in very late 2015, early 2016 that has had a huge impact on the subject and is still ongoing. Brown said taped interrogations were a foundational reform for proper fact-finding during criminal investigations because they allow investigators to properly evaluate the reliability of confessions and potentially deter or catch deceptive police conduct. For example, New York state lawmakers are considering 2 bills that could have altered some of the cases in Gonzalez's report. A bill from Brooklyn State Senator Zelna Myrie, D for Democrat, I presume, would bar police from using false facts. Well, yeah, bluffing, false facts, yes, exactly, to deceive suspects during interrogations and require courts to review the reliability of confessions. Another bill, sponsored by Senator Jamal Bailey of Brooklyn and Assemblywoman Latoya Joyner of the Bronx, would require that youth defendants consult with an attorney before waiving their right to remain silent, among other provisions. The Innocence Project and the Legal Aid Society are supporting both bills, given that old false confessions continue to emerge and the same frightening interrogation methods remain in use, Brown said. A Bronx man who had falsely confessed to killing his mother at age 16 in 1991 had his conviction vacated as recently as last year. And we know exactly who that was, Hugh Burton. This isn't a problem of the past, she said. Absolutely. So, moving on then to my next article. Brent Turvey, I've covered him before. Brent Turvey first came to my knowledge as an expert that was consulted by John Farrak in several of the articles that he wrote about Stephen Avery and Brendan Dassey and the Manitowoc Sheriff's Department. In particular, the article by John Farrak, which details the lack of photographic evidence of the burn pit, severely mars the investigation, was the polite way of putting it. But of course, Brent Turvey, we've come across him in other things, notably in the Daniel Holtzclaw case. We see him being interviewed by Michelle Malkin, not in the Daniel in the Den documentary, but the follow-up to do with the experts. And of course, I've covered the fact that Brent Turvey does online courses in forensic criminology, of which he is a director at the Forensic Criminology Institute, and is actually up in Alaska. So, it says here, I testified as a forensic expert in this case, offering crime reconstruction opinions back in 2015. The crime scene was staged and the evidence was presented falsely. The issue, presenting a presumptive blood test result as a confirmatory test result and then lying about it. The matter went all the way to the state Supreme Court, which ultimately agreed with my findings. The defendants, who are factually innocent, were finally released thanks to the hard work of attorneys Jim Cousins and Andy O'Shea, in concert with Centurion Ministries. So, let's see if I can find the necessary article. Okay. So here we are, this Hartford, I believe, is in Connecticut, and this case is also is in Connecticut. Features a place called Torrington, and as you can see by my backdrop, I'm in Torrington at the moment. So this is by David Owens of the Hartford Courant on July of last year. Judge orders release of man convicted of murder 3 decades ago in wake of state Supreme Court ruling. Here we see a couple of gentlemen here. Let me get rid of that. It's a good day, says Sean Henning, at the right, who leaves Torrington Superior Court on Tuesday afternoon with Ralph Birch. Henning and Ralph Birch were convicted of murder in 1989. The state Supreme Court overturned their convictions and they made their first appearance back in Superior Court on Tuesday. Their case was continued until July 26, when prosecutors must decide whether to retry the men. Torrington, 3 decades after Ralph Birch was locked up for a murder he insists he did not commit, a Superior Court judge Tuesday ordered that he be released as the state considers whether to seek a new trial for Birch and Sean Henning, both of whom were convicted of the 1985 murder of a New Milford man. Judge John A. Danaher's order followed a brief hearing Tuesday in Superior Court in Torrington that was prompted by a unanimous state Supreme Court decision to overturn the 1989 convictions of both men and to order new trials. Henning was already free on probation when the High Court ruled last month. Birch was an inmate until Tuesday, when stepped into freedom and the embrace of his mother. I feel good. It's about time, Birch said a moment after walking out of the Torrington courthouse. It's been a long time coming. It seems like it took a lot longer than it should. But I've got a lot of good people on my side, in my corner, and they fought for me. The High Court tossed the convictions for the 1985 murder of Everett Carr after finding that renowned forensic science expert Henry Lee testified inaccurately about blood evidence at the 1989 trial. Henry Lee, we came across him, didn't we, in the staircase? Birch and Henning, along with Dwayne Deaver, who he wasn't very complimentary about. Anyway, Birch and Henning are both free on promises to appear in court. Until Tuesday, but Birch was an inmate at the Osborne Correctional Institution in Somers. Henning, 50, who has been free on probation since 2018, declined to comment on the advice of his lawyer, Craig Raab, who also declined to comment. Henning and Raab stood by and smiled as Birch spoke with reporters. Sean Henning kisses Kate Gurmond, Executive Director of Centurion, outside Torrington Superior Court on Tuesday afternoon. So, Henning is living in the New London area. Birch will be staying with a friend in Simsbury until he can move into a halfway house to begin the transition from incarceration to the community. Both men must both men must check in with court officials each week. Danaher continued the cases for both men to July 26th. Birch, who is 52, said he was a little overwhelmed by his freedom and was looking forward to a steak dinner. Lichfield State Attorney David Sheebach, who prosecuted both men and won convictions in 1989, did not indicate whether he would seek new trials. Such decisions typically follow a review of the evidence, the availability of witnesses, and an assessment of the strength of the state's case, complicating matters in Sheebach's scheduled retirement August 1st. Sheebach was scheduled to meet Tuesday with lawyers for Birch and Henning. Andrew O'Shea, a lawyer for Birch, said there is considerable evidence that has emerged since the 1989 trial for prosecutors to review. He said that evidence undermines the convictions. In addition to what he views as weaknesses in the state's original case, O'Shea said lawyers have uncovered mountains of evidence that proves the men are innocent, specifically the DNA evidence showing not only no trace of them whatsoever, but we found someone else's DNA on the murder weapon, on the victim's body, on these items that are intimately associated with the crime, O'Shea said. Ralph Birch Centre appears in Torrington Superior Court on Tuesday morning with his attorney, Andrew O'Shea, left. Birch said he hopes the state will drop the charges against him and that he'll be able to get on with his life. I am confident that that's what's going to happen, he said. My past experience, I don't know. That doesn't seem the way things seem to go. I hope that's what happens. It seems like the right thing to do. He said his first years in prison were difficult because he was bitter over his conviction for a crime he maintains he did not commit. He said faith changed his life in 1966. I accepted the Lord Jesus into my life back in 1996, he said. Since then, things have changed a lot in my life. Before that, I was pretty bitter. I got into a lot of trouble at the beginning. The first several years of my incarceration were extremely hard. Since I found Christ and since he's been in my life, things have been a lot easier for me. I'll leave the link so that you can have a read of the State Supreme Court blasts renowned forensic scientist Henry Lee and throws out 1989 murder convictions of 2 New Milford men. In the future, Birch said he'd like to be a hospice volunteer and work with children, two things he did while in prison. Since 2001, I've been a volunteer for the hospice program in DOC and sat with numerous people when they've passed, numerous men, he said, and it's an honour. I think I've got more out of it than they have. Henning and Birch were convicted at separate trials for the bloody murder of Carr, who was stabbed 47 times, had his throat slit and whose blood was trapped throughout the house. They were convicted partially on the testimony of Lee, who told jurors that a towel in the bathroom of Carr's home had a spot on it that he had tested and found was consistent with blood. "20 years later, the Innocence Project took on the case and learned that the towel was never tested before the original trials. Subsequent testing revealed the spot on the towel wasn't even blood. Two men convicted of murder with help of false Henry Lee testimony hope DNA evidence will exonerate them." Okay, it is inarguable that Lee, as the representative of the State Police Forensic Laboratory, should have known that the bathroom towel had not been tested for blood. He, like any such witness, had an affirmative obligation to review any relevant test reports before testifying so as to reasonably ensure that his testimony would accurately reflect the findings of those tests, Justice Richard Palmer wrote in a 23-page decision. To conclude otherwise would permit the state to gain a conviction on the basis of false or misleading testimony, even though the error readily could have been avoided if the witness merely had exercised due diligence, Palmer wrote. To conclude otherwise would permit the state to gain a I've just read that bit, Again, forensic scientist Henry Lee defends record in wake of Supreme Court decision, throwing out 2 murder convictions, citing flawed work. The decision made clear that the court saw no evidence that Lee's testimony about the towel was intentionally false or anything other than a mistaken recollection. The towel with the spot on it had been a key component of Sheepak's final argument to the jury in Henning's case. The Supreme Court ruled that if the jury had known Lee had never tested the towel and that his testimony was inaccurate, it would have impacted the way they judged the rest of his testimony. And there we go. Yes, that's the famous Henry Lee. Henry Lee holds a press conference at the University of New Haven to defend his work in forensic science on Monday morning after the Supreme Court ordered new trials for Sean Henning and Ralph Birch, who were convicted in the 1989 murder of Everett Carr. Carr's murder was such a violent attack that investigators collected more than 70 blood samples off the walls, ceiling, floor, and even a hidden cigar box, but none of it at that time matched the blood types of Birch or Henning. When the DNA testing was conducted 22 years later, none matched the 2 men convicted of his murder. Lee defended his record at a press conference days after the High Court handed down its ruling. Okay, so I'll leave the link in the description so that you can have a read of that particular article. As I say, if you're around on Tuesday, 8:30 UK time, 2:30 Central time, I'll be having a chat with one of the real big names of the Scottish accordion seen. John Carmichael. So look forward to catching you then. Probably have something else in between, but I'll be putting in the scheduling the video for that fairly soon. Okay, well, enjoy the rest of the evening. Pleased to say Aston Villa finally managed a win. They beat Crystal Palace 2-0, so we're not completely dead and buried. We're not as bottom of the league as the Adelaide Crows, who, well, okay, we're one level off the bottom, whereas the Crows are right at the bottom. So we're pretty close. But anyway, we'll catch you all next time. Bye for now.